So the Supreme Court just denied emergency review to the New York concealed carry law and the ammunition restrictions that it puts in place. So let's talk about this. But real quick before we jump into this video, if you think ammunition background checks are clearly unconstitutional, go ahead and hit that like button and subscribe. Also want to give a shout out to one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they're huge Second Amendment supporters. So if you want to support a two-way company, if you want to get good coffee, check out the links down below, and if you use the code ARMSCHOLAR, you can get 10% off of your order. As I mentioned in the intro, in this video, we're going to be discussing the recent Supreme Court denial of a case which challenged the state of New York's new concealed carry law and also the ammunition restrictions that it puts in place, and that was through the CCIA. The case we're going to be talking about in this video is called Gazzola v. Hockel. This case involves a challenge to the state of New York CCIA law, which they passed in direct defiance to the Supreme Court's recent decision in New York State Rifle and Pistol Association versus Bruin. More specifically, the current emergency application was submitted to the Supreme Court for them to decide whether or not the new ammunition restrictions, which were just put in place in September, are a violation and need to be at least halted while this case is making its way through the Second Circuit. The Gazzola case focuses on the impact that the CCIA specifically has on dealers and gun stores, one of those aspects being the new ammunition background check system that it puts in place. These businesses argue that the CCIA is unconstitutional because it violates the Second Amendment and the Supreme Court's recent Bruin decision. The businesses argue that they are a critical component to the right to keep and bear arms, and that the CCIA attempts to regulate them out of existence and also puts in place these unconstitutional restrictions, like restrictions on the purchase of ammunition. This whole lawsuit sprung up as a result of the Supreme Court's recent decision in Bruin. In Bruin, the Supreme Court struck down New York's May-issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition. One of the primary findings of Bruin in that decision was that the government bears the burden to prove that their restrictions are based in the history and tradition of our nation. However, despite that decision, the state of New York rushed through the Concealed Carry Improvement Act, known as the CCIA. This new law made the permitting scheme even worse than the one that existed prior to Bruin and put in place additional restrictions like this ammunition background check system. In this case, the plaintiffs originally sought to obtain a temporary restraining order and then also a preliminary injunction from a district court. However, the district court rapidly denied both the TRO and also the preliminary injunction. The plaintiffs then submitted an interlocutory appeal up to the Second Circuit. The plaintiffs sought for the Second Circuit to find that the denial of the TRO and also the preliminary injunction by the district court was in fact an error. However, a three-judge panel in the Second Circuit originally denied the appeal, saying that the lower court had weighed the applicable factors and found that the district court was in fact correct. In response to that original denial, the plaintiffs submitted a petition for a writ of certiorari before judgment to the Supreme Court. This was an interesting mechanism to seek early Supreme Court review of a case. This type of petition invokes the Supreme Court's statutory power to grant review of a case before the lower court reaches the final determination on the merits of any judgment. Ultimately, what ended up happening is the Supreme Court denied the writ of cert before judgment. Instead, the Supreme Court indicated that they would wait for the Second Circuit to decide the appeal before stepping in. At that time, that wasn't really surprising because the Supreme Court had already denied emergency review in other cases which were challenging the CCIA. We had cases like the Antonyuk case, which was submitted to Justice Alito and some of the other justices, where emergency application and emergency review was denied, but we did get a kind of mention by Justice Alito that they were interested in the case, and they did warn the Second Circuit that they needed to at least expedite review of these cases, or at least give some sort of rationale of why they denied the preliminary injunctions or hold an expedited hearing, and if they did not, then the Supreme Court could potentially take review of this case. Now in March, the 5 CCIA cases, including the Gazzola case, were argued on an expedited basis in front of the Second Circuit. But since then, we have heard nothing, and there has been no decision from the Second Circuit. Now, in the meantime, the state of New York has now put in place the ammunition background check system, which took effect on September 13th. The fact that this new ammunition restriction is put in place and the inactivity of the Second Circuit led the plaintiffs in Gazzola to once again go up to the Supreme Court on an emergency basis and seek for the Supreme Court to step in and at least halt the ammunition background check system until the Second Circuit issued their decision. The plaintiffs in the case sought for the Supreme Court to halt the enforcement of the ammunition background check law, at least while the appeal process is going on. One of the main reasons is because of how the Second Circuit's delay has been taking place. They're not making a decision, and also how the essential result of that is now that the ammunition background check system has been put in place and went into effect on September 13th. Now, the emergency application was originally filed to Justice Sotomayor, who is the justice responsible for hearing emergency applications that come out of the Second Circuit. That emergency application was filed to Justice Sotomayor on September 11th, but interestingly, the very next day, Justice Sonia Sotomayor denied the application. That then led to the Gazzola plaintiffs refiling and resubmitting the application to Justice Thomas. There are some procedural rules about who has to review it first, and then after there is a denial, like what happened with Sotomayor, then they can go to any justice, and so they picked Justice Thomas. The case was then distributed to the Supreme Court for conference on October 6th. The conference is essentially when the court gets together and decides whether or not they want to grant review to a case or whether or not they want to deny review. Well, today we received an order that came out of that conference, and the Supreme Court has decided that they want to deny review to the Gazzola case. So they did not grant review to this case. That means for now, the Supreme Court will not step in on an emergency basis to enjoin the current ammunition background check system that is taking place and is potentially preventing many people in New York from being able to purchase ammunition. Now, from the beginning, I said it was very unlikely that the Supreme Court would step in on this case, especially in its current posture. The Second Circuit has heard all of the CCIA cases, including Gazzola, and we're currently just waiting for them to issue their decision. The Supreme Court, for the most part, has taken the position in all these cases and other cases that they're not going to step in on this two-way issues, especially at an early stage. Instead, they're going to give the lower courts the opportunity to decide these issues before stepping in. It's also telling in some ways that there was no dissent on this denial. That means that none of the judges felt strong enough against the denial to write something about why they denied it, or maybe being upset that they denied emergency review. I will also note that the recent emergency applications for relief that went to the Supreme Court involving the ATF did not go in favor of the Second Amendment. Recently, you had the ATF go to the Supreme Court and ask them to stay the vacature of the frames and receivers rule. And in that case, Justice Roberts and Barrett joined the liberal justices to grant the stay in the ATF's favor. And then even more recently, you had Justice Alito put in place an administrative stay. Now, in my opinion, I don't think it's super telling that Justice Alito put that administrative stay on Vanderstock. We will have to see how the full court decides. Remember, Justice Alito was against the original stay that was put in place. The stay on the vacature, Alito and Gorsuch and Thomas wrote against that. So I don't think that that's super telling that at least Alito put the administrative stay right now in Vanderstock. We will see how that plays out. But again, it's telling that Supreme Court, at least right now, seems to be hands off on these two-way cases and is simply probably just going to wait until they issue a decision in the upcoming decision, which is going to be the Rahimi case. But right now, at least in Gazzola, they're hands off and they're letting the Second Circuit make their way through the process. So unfortunately, I know this is one of those situations where a lot of New Yorkers were hoping that the Supreme Court would step in early and grant some sort of relief, but the Supreme Court is staying true to their process and they're going to wait for the lower court to issue their decision. They did this earlier in the Antonyuk emergency application, and they also did this earlier in the Gazzola case, and they're just simply doing it once again. So that's what's recently happened with the Gazzola emergency application that went up to the Supreme Court that a lot of people in New York were waiting for. The Supreme Court has denied review in this case, and it appears that they're opting to once again let the lower court resolve the case before they're going to step in. So now we will continue to wait for the Second Circuit and wait for them to issue their decisions. But again, they've been sitting on the decisions for a long time and they have not issued them. I believe they heard the cases back in March, so we're still going to be waiting. But of course, if anything else develops, I will let you all know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. Also want to mention that one of the best ways to support the channel is by subscribing. I looked at some of my analytics, and about 60% of you guys who watch the channel frequently are not actually subscribed to the channel. And also just go back and check. I know a lot of people comment quite often that they've been unsubscribed from the channel. So just make sure you're still subscribed, and then also make sure you have all notifications on, because that is one way that you can ensure that you actually get these videos when I upload them. But regardless, thank you guys so much for all of your support. Don't forget to like and subscribe. And never forget, the station was built by Armed Scholars, and the station will be maintained by Armed Scholars.